So, welcome everyone to the first webinar of the Canadian Forum for Business and Human Rights titled The EU Corporate Sustainability Due Diligence Directive, Opportunities and Challenges for Canada. First, let me start by acknowledging that the University of Manitoba campuses and research spaces are located on original lands of Anishinaabe, Innuak, Anishinaabeg, Dakota, Oyat, Dane, and Inuit, and on the national homeland of the Red River Métis. I'm excited to moderate the first forum webinar. The forum is Canada's first national research and dialogue network dedicated to advancing the field of business and human rights. The panel today will situate contemporary legislative developments on human rights due diligence in Europe within the Canadian context. Specifically, panelists will unpack the opportunities and challenges that the Corporate Sustainability Due Diligence Directive, in short, the directive, poses for Canadian corporations in a global context. They will also consider whether Canada should respond and what such a response would entail. Please permit me to introduce our panelists, and their full profile is on the forum's website, so feel free to check their full profile. The first is Dr. Nadia Bernaz. She's an associate professor in the law group at Wageningen University. I hope I'm pronouncing that correctly. In the Netherlands, she is also a director of the Jean Monnet Center of Excellence on Corporate Sustainability and Human Rights Law. She has published numerous academic articles in law and business journals and has been teaching business and human rights since 2010. She founded and runs Right As Usual, a business and human rights blog post, and is the upcoming editor-in-chief of the Business and Human Rights Journal, starting in January 2026. Please join me in welcoming Nadia. The second panelist for today is Dr. Sara Seck. She's a professor and the director of the Marine and Environmental Law Institute at the Schulich School of Law, Dalhousie University in Canada. Her research and teaching interests are situated at the intersection of international environmental and human rights law, with attention to business responsibilities, climate justice, and the protection of the marine environment. Our work is informed and inspired by feminist, relational, and intersectional approaches to legal analysis as well as TWIL. So here is an additional information about Sara. Sara supervised my PhD thesis, so please join me in welcoming Sara. Right. So the third panelist, and not the least, is Dr. Penelope Simons. She's a full professor at the Faculty of Common Law, University of Ottawa, and the director of the Human Rights Research and Education Center, a global leader in business and human rights. Her research focuses on the human rights implications of domestic and transnational extractive sector, state responsibility for corporate complicity in human rights violations, the regulation of transnational corporations, gender and resource extraction, gender and business and human rights, as well as intersections between transnational corporate activity, human rights, and international economic law. In 2018, Penelope was awarded the Walter Tanapolsky Award, recognizing her as an individual who has made a significant contribution to human rights. Please join me in welcoming Penelope and all the panelists. Right, so this would be the order of presentation. First, we would listen to Nadia, who would give us background information about the CSDDD, which of course, going forward, I'll call the directive. Right, so after Nadia's presentation, I'll then pose questions to each panelist in a fireside chat manner. Panelists will be able to respond to my questions and to one another. Afterward, we'll have a 20-minute Q&A session with the audience. And then please remember to post all your questions in the Q&A box while listening to our panelists. We will take them after the panelists' presentations. This session is recorded, and then it will be posted on the forum's website, allowing people to watch later. So at this point, let me start with Nadia. Nadia, could you please explain or provide a background information about the CSDDD, its history, its status, and its trajectory so far?
Sure. I have prepared slides because it's quite tough to do that without some support. So allow me to load this presentation. Yes. Can you see it?
Yes.
Okay. So thank you for the introduction. I'm very happy to speak in this event. And I think my task is, first of all, to set the scene and explain what is happening with the Corporate Sustainability Due Diligence Directive. So I have titled this short presentation, Where Are We Now? I'm now only seeing Penelope, so I don't know if this is normal.
Yes, we can see you. We're just,
Okay.
yeah, we just.
Then I'll go straight in. So I will, my presentation is in three short parts. First is giving a little bit of context. How did we get to the directive and why did the European Union think that it was a good idea to adopt a directive? Then I want to briefly go into the contents, who is covered to do what and how are they supposed to do it. And then finally, I want to talk about the latest developments, and that is the omnibus proposal, and explain the timeline for this and the main proposed changes. So that's the goal for the next few minutes. So towards the directive, I'll start by briefly introducing due diligence legislation. So essentially, when we talk about due diligence legislation, we mean legislation that requires large companies to identify and address their negative human rights and environmental impacts. So in a nutshell, that's what corporate human rights due diligence legislation means. Large companies, they should know and address their impacts, human rights and environmental. And of course, that type of legislation is inspired by the 2011 United Nations Guiding Principles that also introduced this idea of due diligence, except that the guiding principles are non-binding soft law, and when it comes to legislation, we enter hard law, and therefore, in this process, some changes are made to the concept. But in general, we keep the same idea. Yeah? Companies need to know and show and address their negative impacts. So in Europe, and my apologies for this map because it is not up to date, it's a little old. However, it has the advantage of showing that there's activity in various European countries around due diligence legislation. Indeed, some laws were adopted, but also even outside of actual legislation being adopted, we do have a lot of NGO, civil society, various actors' activity around this question. So in other words, this is meant to illustrate the fact that things are happening in different European countries. And that is what prompted the European Union to intervene. So first, let me say that the EU Corporate Sustainability Due Diligence Directive, or CSDDD or CSDDD, is part of an entire range of, we could say, regulatory initiatives connected to business, human rights, and the environment at the EU level. Very many initiatives that all basically pertain to the same idea, which is that companies have human rights impacts, have environmental impacts, and we need to somewhat regulate them so that this impact is mitigated or ends. So I would put in all these categories different types of measures like import control measures, also corporate reporting, and a bunch of other things around single-use plastics and the right to the obligation for manufacturers to create products that can be repaired. These kind of, broadly speaking, sustainability legislation is very easy to get lost in this, and I do sometimes. And so that's why I'm recommending this great report from the Danish Institute for Human Rights, which you can find online. They're regularly updated, and it's really super clear, and it has these tables about, you know, what is it about, how all these measures basically intersect with each other. So I always plug this in when I talk about the directive, because it's a really nice resource. So that's the context. Lots of countries doing their own thing, and also a lot of initiatives in the EU around those questions. And the rationale for the directive was really harmonization, because European institutions, and particularly the Commission, they hate it when countries do their own thing and take the risk of disturbing the internal market of the EU. And therefore, we see already in 2019, during the Finnish presidency of the European Union, this agenda for action that talks about this fragmented landscape of measures, and basically saying that this is the moment then to harmonize, because they don't want different countries to do different things in their own on their own. Yeah, so that was really the rationale, because of all these movements in various countries, and in some countries some laws being adopted, they decided to intervene. So what is in the directive? Very, very quickly, who does what and how? Key elements. So first of all, which companies? We're talking about very, very large companies that have over 1,000 employees and over 450 million annual turnover, 50 million euro annual turnover. And also, interestingly, and I think we'll talk about this quite a lot today, the directive applies to non-EU companies that have a business in the EU, that have over 450 million euro annual business in the EU. In terms of the scope, the directive applies to the company's own operations, but also the company's subsidiaries and the company's business partners in what it's called its chain of activities, which is another word for value chain, and it includes upstream partners, but also some downstream partners, with some exceptions. So that's the scope. And then in terms of material scopes, it's about adverse environmental impact. And there we have a list of conventions in the annex. Interestingly, the Paris Agreement is not part of the due diligence obligations. There's a different provision on that, which I can talk about later if you're interested. And also, of course, it is about adverse human rights impact. And there too, we have a list of rights and a list of conventions. So it is about both human rights and the environment. And in terms of obligations, the core of the directive is Article 4, which asks companies to identify, prevent, mitigate, and bring to an end their adverse human rights and environmental impacts, like I said, arising from their own operations, their subsidiaries' operations, and the operations of their business partners in their chain of activities. There's a strong provision on meaningful stakeholder engagement as well. In terms of compliance, the directive says that EU countries need to create national supervisory authorities that will have investigative powers and also powers of sanctions in case the companies do not conduct due diligence properly. And finally, there is a liability provision that explains that liability will arise in case of negligence or intentional failure to comply with the obligation to prevent or end the harm, and causation between the failure and the damage. So we can maybe talk about this as well later. So was the directive. that was adopted in May 2024 after a lot of discussions. And then in February 2025 came the omnibus proposal. So already a few months after the adoption of the directive. So this is the timeline that we had. So you could see that in May 2024, the directive was adopted after the usual EU procedure for lawmaking, a proposal from the Commission, a position called General Approach for the Council, a position for Parliament, a trilogue between the three main institutions, and finally an adoption in May. The normal course of action after that should have been 2 years for countries, EU member states, to transpose the directive, meaning turning it into domestic law. And then in 2026, we would have had an entry into force of the directive after transposition in member states. And then in 2027, 2028, companies would have started to comply, hopefully, with the directive. And when the directive was adopted in May 2024, I, together with a group of people, we published this article that was called The Final Political Compromise. And we're very happy and proud about it. Needless to say, things changed because, like I said, in February 2025, the Commission came with what it called an omnibus sustainability rules simplification package. So what is this? That is a proposal to take a number of EU sustainability legislation, including the CSDDD, and to renegotiate them, to change them, because in their opinion, in the opinion of the Commission, they are too complex and they are too difficult to, basically they are too difficult to comply with for companies. So they came up with this idea of simplification. And the first step when you have a process like this, first of all, is to stop the clock, because otherwise transposition would have had to, like, states were under the obligation legally to transpose the directive. So in April 2025, a stop the clock directive was adopted, which does what it says on the package, which is stop the clock. Hold on, states, before you transpose, we need to talk, and we are actually renegotiating. And where we are now is in the fall 2025, we are in the middle of the trilogue, and that means that the EU institutions are talking to each other to find a compromise that will lead to the adoption of a revised directive for the topic that interests us. The proposal of the Commission, and we don't know what is going to be adopted. What I can tell you is what is in the proposal of the Commission. So that's the basis for the trilogue at the moment, these proposals. And this proposal makes key changes to the CSDDD. First of all, in terms of value chain scope, we're now talking about only tier 1 business partners. That means that it is not the suppliers of your suppliers of your suppliers, it's your suppliers. Yeah. Tier 1, only one level of suppliers. Secondly, the stakeholder engagement provision in the directive was very, let's say, generous and broad, in that they had a very broad understanding of who is a stakeholder. Now in the CSDDD, in the omnibus proposal, this engagement is reduced to engagement with stakeholders who are directly affected as opposed to affected. In terms of compliance, it's also hugely changed. Instead of monitoring the effectiveness of due diligence measures, the national institutions would have to do that every 5 years instead of every year. And also, there was a minimum cap on sanctions. So there was this agreement that if companies are sanctioned, it should be a substantial fine, minimum 5% of the annual turnover, and that is gone. from the in the omnibus proposal. And on liability, I told you there was this point in the original directive to have a EU-wide liability mechanism. Now, in the proposal, it is left to member states to use their own systems, so with no harmonization on this point. And the final point I want to make is, for now, is the concept of broader harmonization that perhaps is not something that you'd be familiar with too much. Essentially, when directives are adopted, EU member states have to transpose, like I said, they have to turn this into domestic law, and they have some leeway, some flexibility about how to do this. That's the principle of a directive, right? They can decide how to do things for themselves as long as it's in line with core principles. And what the proposal in the omnibus is now that this scope of maximum harmonization applies to the provisions that regulate the core aspects. That's another way of saying that member states cannot adopt more stringent national provisions. They would have to stick to what is in the omnibus. That's a very important consequence, especially for countries that already have due diligence legislation that are stronger than that. So that should be interesting legal questions down the line. I've spoken a lot. I've done as quickly as I could, but I will leave it at that and stop sharing my screen.
Thank you so much, Nadia. You've set the stage for everyone, and it's you've actually set some very thought-provoking issues that I know Penelope and Sara would speak to. But let me quickly follow up with this. Now, Nadia, can you explain the implication of the directive and its proposed amendments for global BHR standards and supply chain governance? What's the implication of the directive in that regard?
You know, it's difficult to answer this question. I've been thinking about it. We had the questions in advance, by the way, for the audience. This is all set up. It's very hard to say because at the end of the day, if you really look at the provisions, even of the original directive, let alone the omnibus, we're talking about very few companies that actually pass that threshold. More than 1,000 employees, it's not very many companies. And so already, it's not like this is not how the revolution will happen. Let me put it that way. You know, it is very few companies. It is not a groundbreaking changes that would be set in, you know, put in place. Also, you could also make the point that we've had the UN guiding principles for what, 14 years, 14 and a half years. And already this requirement to conduct due diligence, in theory, all companies should do it already, right? So in other words, what the directive is asking is to do things that most companies should already be doing. So the implications for global supply chains, for me, we shouldn't overstate those, even if we stayed with the original text. At the same time, it is symbolically important. You know, I think the value of such legislation is also to continue a conversation on these questions. And it's much easier when you have a concrete piece of legislation than when you have to go talk to companies with your UN guiding principles, you know, which only get you so far, I think. So that's my middle of the road position on what that can do.
Thanks, Nadia, for that excellent intervention. Now, Penelope, let me come to you. What does the directive mean for Canadian investors navigating international business and human rights norms, especially, you know, managing the Canadian EU interface? Now, at least putting in mind what Nadia just said about it's not going to revolutionize the world. So how should Canadian corporations then navigate this interface?
Yeah, I think the problem is, in terms of its impact for Canadian companies, is that it's only going to cover a small number of companies that have that huge amount of revenue in the EU. So, and I think to that extent, some companies, depending on what happens with the omnibus, the changes, there are going to be some Canadian companies that are then held to mandatory human rights due diligence standards that other companies are not, and they can just engage in business as usual. And so, it could result in those companies that are caught by the directive in trying to push Canada to do something to kind of level the playing field, bring in legislation that would change that. There have been studies that were done in the last 5 years that demonstrated that there appeared to be increasing support for mandatory human rights due diligence in Europe and in the UK. Now, this is probably not the case in Canada. Canada has always, supported its companies in the sense of, pursuing voluntary self-regulation type of obligations, if we call them that. And there have been, we have an extractive industry that's pretty powerful, and they have vehemently opposed any kind of modest moves to create even remedies like the Canadian Ombudsperson for Responsible Enterprise, where we saw that that institution start out with an announcement where it was going to have powers to actually compel witnesses and to compel document production by companies, ending up without those powers, and so therefore not able to engage in the kinds of credible investigation that it was supposed to do. Having said that, there's a lot of uncertainty and some potential liability for Canadian companies who are operating globally because there is transnational human rights litigation going on in various countries, sometimes against Canadian companies, but also in Canada. And so, if these companies are adopting certain voluntary standards, those voluntary standards can sometimes have a legal effect. And this has certainly been the case in some cases. For example, in Canada, in the Chalk and Hudbay case, or a company had adopted the voluntary principles on on security and human rights. That was one factor that led the court to finding that there was this prima facie duty of care vis-a-vis the plaintiffs. So I guess I think that there's only going to be these very large companies, and I don't know. I think we have to see what those companies are, who they are, what sector they are that are going to be operating, that are going to feel the impact of this directive, and then they have to assess whether that's undermining their competitiveness, because they will have to put in place human rights due diligence practices and processes, and as I said, that could lead them to lobby the federal government to take action. But I think this is a wait and see. But there will be this uneven playing field for those that are caught by the directive.
Thanks, Penelope. And I think that sets the stage so well for Sara. And this is a question I've been itching to ask Sara for the past 1 or 2 years, looking at the directive. Sara, you wrote an excellent paper on unilateral home state regulation, right? And the question is this: how should Canada respond to the directive given its extraterritorial nature, right? I know you've made a very fantastic argument about TOEL, right? So does your argument in that paper, does it extend to developed countries like Canada?
So thanks, Akin, for the question. Extraterritorial is my most hated and loved word.
We debated this during my PhD.
Yes. And we can explore why. I think it was Lowenfeld, a private international law theorist, who said many years ago that you should beware the word extraterritorial, because as soon as you hear it, you know what the speaker is thinking. And by this, I think Lowenfeld meant that the word invokes concerns over sovereignty interference. And so as soon as you paint legislation with the extraterritoriality brush, you're suggesting right away that there's something illicit or problematic about it. And I think there's something that we can dig into about that in a moment. But the rolling back, if we don't describe this legislation as extraterritorial, which just invokes this territorial, extraterritorial binary, we can ask more sophisticated questions about what is the nature of the relationship to which the obligations are designed to attach. And then it becomes much more nuanced. And I think if you take a look at Canada's legislation, addressing forced labor and child labor, you'll see similar kinds of things. How do you know when Canada has jurisdiction to regulate companies that have a relationship with Canada? If they do a certain amount of business here, there's nothing wrong with putting requirements on them. And that's exactly what the EU has done, and that's exactly what we see in the legislation that's passed by Canada. So the question so I think there's a long history of these kind of nuanced pieces of legislation being put in place. And I think in that paper you referred to, I made reference to the original legislation addressing foreign corrupt practices that was put in place by the US, and then it applied not just to US companies, but also to European companies. And at a time when bribery was actually legal, bribery of foreign officials was actually tax deductible in Europe. And so I think we could call it extraterritorial, or we could just ditch that and focus on, is there a legitimate relationship to which this legislation is attaching? And then what are the requirements? And we see in both, you have to be doing a certain amount of business in that area, and then this law is being applied to you. As we've said, in fact, it's just going to involve a very small number of companies. And there are two different responses. Penelope has suggested that one could be that maybe this would push for a leveling of the playing field within Canada, and so maybe for Canada to pass similar legislation. But of course, historically, the alternate response was putting in place blocking legislation that prohibits companies from complying. I don't think that's going to happen. I don't think anybody really wants that. But that is the sort of power of territoriality. There's a different question and a different kind of concern, though, which I delved into in that paper. And I think this perhaps gets more to the heart of the nature of this kind of legislation and who it's designed to serve. So the other version of the extraterritoriality concern is that this is rich countries, historically countries that played a big role in colonialism, who are yet again imposing their laws on conduct that is taking place in the global South. And so there's something inherently colonial or imperialist about this that should therefore urge caution. I think that is a critique that really deserves attention, but I also think it's one that can be kind of unpacked. And this links into the way in which the word extraterritorial, raises this fear of sovereignty infringement, right? So you don't want the powerful, rich colonial states imposing their laws on, other states in a way that is illegitimate. But the question is that what this kind of law is designed to do? And how could you design a law of this kind so that it is legitimate? And so I think one of the pushbacks is, if the aim of the law is to protect human rights and environmental issues, then are those people in the countries whose human rights and environmental concerns the law is designed to protect, what did they actually think about the law? Are they living in a state in which the government is responsive to their human rights and environmental concerns? And here I think we get into sort of one additional flip, which is the law structured in a way so that it applies both within the states that are regulating and to other states? And I think we'll see that I think the EU's CSDDD is structured in that way, as is the Canadian law in relation to forced and child labor. It doesn't just apply outside of Canada, it also applies within Canada. Then you're talking about, I think, broader questions of taking countries trying to pass laws to take responsibility for their human rights and ecological footprints. That is in something that I think we could and should all aspire to do. And there's nothing extraterritorial about that, although the way it's done could lead to consequences in terms of sovereignty infringement and other things. I'll stop there, but obviously I could happily talk for hours about this, but you do not want to hear that now.
Sure, Sarah, and I think I'll come to you after this question. Now, let me turn it to Penelope. And I think this question is for you and Sarah, Penelope. And the question is this. Are there current legislative or regulatory developments in Canada that cover or seek to cover the scope of the directive? And I'm referring to that constitutional doctrine of covering the field. So is that something that we are looking at in Canada, or is there a potential for it?
Okay, so is there a potential for it? Yes, there is a potential. Whether there's a political potential for it is another question. So that currently in Canada, there's no legislation similar to the EU directive that would impose an obligation on companies to undertake human rights due diligence. What we have right now in Canada is a policy that was released in April 2022. It's called the Responsible Business Conduct Abroad, Canada's Strategy for the Future. And what it does is it makes due diligence, human rights, environmental, anti-corruption, and other due diligence a key expectation, along with companies adopting the guiding principles on business and human rights and the OECD guidelines for multinational enterprises on responsible business conduct. And as a part of this policy, the government promised to release a due diligence standard for companies to follow, but 3.5 years in, we're still waiting for that. So that has not yet come out. So now it's important to emphasize that human rights and environmental due diligence are not mandated. This strategy is really framed as a risk management strategy for businesses, that they should undertake this because they will then, perhaps not get themselves into messes where they could incur liability. The strategy relies on certain reflexive mechanisms to incentivize companies to engage in responsible business conduct. What reflexive mechanisms means is that they are mechanisms that, companies will look at this and think, oh, if I have to do this, or if I have to do this, then maybe I should undertake human rights due diligence. So it's to get companies to kind of think about doing what the strategy expects them to do. And so what companies are supposed to do is engage in or make a range of attestations or integrity declarations where they're seeking trade commissioner support, so federal government support for their businesses abroad. And the threat that support could be withdrawn where businesses fail to sort of comply with Canadians' responsible business conduct laws and policies and standards is something that's supposed to incentivize businesses to follow the strategy. But really, the strategy is about voluntary self-regulation of companies. And the hope is that by making these attestations and integrity declarations, they'll consider the risks and then put in place due diligence practices. There's been very little evidence to show generally that this has done much. It's not particularly new. There was a very good private members bill on human rights and environmental due diligence that was tabled by an NDP member, Peter Julian, back in March of 2022, so just before the policy was announced. And it was called Bill C-262. It was never picked up by the government, and it died when Parliament was prorogued in January of this year. So it would have, if it had been enacted, imposed a duty on companies to avoid causing or contributing to adverse human rights impacts abroad by entities in their corporate groups, so subsidiaries and affiliates, or through their business relationships, so through supply chains. And it would have imposed liability for harm caused through the failure to comply with those duties. And it would have required companies to develop and implement human rights due diligence procedures in relation to their activities and report annually on their processes, and then take measures to identify and assess those risks. It would also have created a private cause of action, and this was important for those who had suffered harm because the company had failed to meet its duties to prevent adverse impacts, and also a cause of action for certain persons to bring a claim against a company for failing to develop due diligence procedures. So there was two prongs to the enforcement. So that law, unfortunately, has died. There is a campaign going on right now to push the government to adopt human rights due diligence legislation. I think it's starting this week, Canadian Network on Corporate Accountability. But we do have a law in place. It's called, Sara mentioned it, the Fighting Against Forced Labor and Child Labor in Supply Chains Act. Such a funny name. But it's just a reporting law. It doesn't require companies to take any measures to engage in due diligence to eradicate forced or child labor in their supply chains. It just requires them to report. So again, it's a reflexive type of legislation that is sort of based on this hope that if companies have to say what they're doing or not doing, that they'll do something. So it's modeled on the outdated laws of the UK and Australia, which have long been proven to be ineffective in preventing forced labor and other forms of modern slavery. The legislation also modified the customs tariff in Canada, which already prohibited goods made by forced labor from being imported into Canada, but now it's illegal to bring in goods made with child labor. But again, or not again, but the Canada Border Services Agency has a very weak record of enforcement. And so there was a report that was in the House of Commons last week that said that they had detained 34 shipments since the act came into force last January, but only one had been denied entry. I've already mentioned the core that we have that was supposed to have powers to compel witnesses and documents, but I want to add a couple of things about that. The Canadian ombudsperson who had the position to start with, Sherry, I can't remember her last name, Hoffmeyer, got that? Yes, she was not renewed after her first 5-year term, and then there was an interim ombudsperson in place for a year, and now the position is empty at Global Affairs, and Global Affairs is conducting a review on it. There hasn't been any official announcement on what the government's planning to do with the core, so the future at this point is uncertain, and there are complaints pending, so 32 according to Mining Watch. So there are many people who have tried to use this as a remedy, and there's been this period when nothing has happened. I'll leave it there.
Thanks, Penelope. I think you've taken a broader view of the regulatory development. Sara, you want to add anything to that?
The only thing I'll add, not surprisingly, is the importance of not forgetting and perhaps, I think, putting a lot more effort into the OECD guidelines, their promotion, and into the national contact point mechanism. And I say that for a number of reasons. First, my understanding, at least, is that the original version of the EU CSDDD was designed to align with the OECD guidelines approach, the OECD's RBC approach. Although I understand, and Nadia can correct me on this, that the Ombuds version is moving out of alignment with that. But if we think about the OECD and its RBC landscape, first of all, this is something to which over 50 countries are adhering. So and I think at this point in time, multilateralism is actually really important. If we're keen on multilateralism, we should really engage with what it is that the OECD guidelines require. Canada is, in fact, obligated to promote the OECD guidelines for multinational enterprises on responsible business conduct to Canadian-based companies. It does it a bit. It could do it far more. Most people don't even know that these exist. Most people don't know that there's a national contact point mechanism where you can bring complaints that companies are out of alignment with the OECD guidelines. Of course, the current structure of the national contact point housed within global affairs has been much critiqued. It is one of the poorly designed NCPs, and so there has been a real lack of trust with civil society who won't use it. Groups who have found that there are some huge structural and structural issues. But again, this could be reformed to align with some of the best practices from select EU countries, which actually have NCPs that appear to function and serve a particular role. And I think the question then is, what is that role? It isn't the binding hard law approach, but what it is an opportunity to be part of a conversation about what responsible business conduct actually looks like. And importantly, the OECD guidelines immediately embedded the human rights due diligence approach of the UN Guiding Principles in an amendment in 2011. The OECD guidelines have chapters that cover a whole range of other things, including a very rich, what is now quite a rich, not perfect, but quite a rich chapter on environment that is fairly holistic. Lots on not just climate, but also biodiversity, circular economy, all kinds of different pieces in here. And of course, it's got chapters on labor and on how companies communicate with consumers about issues like environmental footprints. That's something important. Of course, we have legislation dealing with that, but how these align would be important. I think there's just a tremendous amount of work that could be done to carve out a culture, to promote a culture of responsible business conduct in the Canadian landscape that would not just focus on the conduct of businesses operating outside of Canada, but would also bring that conversation within Canada, which is precisely what the guidelines and the NCPs are supposed to do. But that's only going to happen if the federal government takes it seriously, and also if other Canadians working in this space think it's worth putting in the effort to promote this. And I often feel like not many people agree with me on this, but there it is. I really think that would be helpful. And again, I think it is related to the CSDDD conversation, because I think that's where that initial, some of the design of the initial legislation came from. The other thing I would say is we are seeing moves towards human rights due diligence type legislation in other contexts, in the Asian context, for example. And that is also something that is influenced by the OECD approach. So this is a global conversation and a global tool that could be used much more than it currently is.
Thanks, Sarah. I think I'm just going to start off with that global conversation. Now, this question is to the three of you, and I'll probably start with Nadia on this. Right. So the question is this: what are some of the opportunities and challenges for implementing the directive in the EU states and countries abroad? And in answering that question, I want us to pay attention to both developing countries and developing countries. Is there a dichotomy between these two contexts? Nadia.
Yeah, thanks. So I really want to echo what Sara just said, because I think seeing the directive in isolation is not helpful. It is so narrow. It's not even there. You know what I mean? At the moment we speak, it was adopted. There's a stop the clock. That's it. So concretely, nothing has happened. You know, not a single compliance measure has been taken under the CSDDD. And yet we've been talking about this for years. Like my slide about the timeline is, I started it in 2022, but with years, this has been, you know, so many of those events have been on this. And yet, in the background, at the same time, we have the OECD, for example, who's done a huge amount of work in engaging in conversations with various actors and making real progress on these questions. And it's an anecdote, but when we launched the Center of Excellence that we have in Wageningen, we had the chair of the working party on the OECD Responsible Business Conduct, Kristin Kaufman, who, this was in the middle of the omnibus. We launched in February. The omnibus proposal was just there, and everybody was running around like headless chickens. And what are we going to do? And she basically said, listen, my job doesn't change. I've been engaging with companies, talking about responsible business conduct for I don't know how many years. Today, the CSDDD is in jeopardy, and now it's gone worse, obviously, since then. But the conversations continues, right? So the opportunity is one more opportunity. The opportunity to answer your question that the CSDDD opens is one of many. Now, we have other instruments to engage companies on these questions. Of course, having legislation is helpful to have these conversations because you can be a little firmer in your demands. And also, of course, it is the EU, which is a huge market and an economy, it's an economic heavyweight, whether we like it or not, that does matter. But on the other hand, it is just one among many. So the opportunity is there, but I think we should be careful placing all our hopes in that instrument because it's very dangerous, as we see, because now it's not going too well. But also beyond that, it opens all sorts of discussions about the Eurocentric part and the neo-colonial part and all that, which of course are important and we should have. But this is a global movement. This is not a European-led movement. I think this is the message that we should stick to.
Thanks, Nadia. Penelope or Sara?
Penelope, you go ahead.
Okay, sure. I guess I have a pretty short answer to this in terms of Canada. I think the directive, even as amended, well, we don't even know what it's going to look like as amended. So maybe I'm saying this and it's, it wouldn't. But I think in some ways, if we're thinking of the original directive, it's something that could provide political cover for the Canadian government in terms of if they wanted to enact human rights due diligence legislation, because there would be companies that would be likely pressing for some sort of changes in Canadian legislation, so they're not bearing the cost of having to comply. And Canada now is seeking out new trade relationships, and so maybe there's even some political conversations that are going on, among leaders about, we have these types of regulations in place, and Canada has not done a lot of this, and they should be sort of pulling up their socks and doing some more. And maybe that might be. It's possible that could be part of the discussions because, the range of different rules and directives that have come out of the EU on sustainability issues, there's nothing like that that's come out of Canada.
Thanks, Penelope. Sara?
So I'll just offer a few reflections as somebody who spends a lot of time in the environmental space. And there is no doubt that there is huge pressure currently for rollbacks in environmental laws more generally. So we're seeing that clearly in the US, but of course the US is a bit of a disaster right now. But I think Nadia made reference to one of the EU, the forestry one being, stopped, but there's also, I've seen EU reference to simplifying initiatives aimed at simplifying environmental laws more generally. We see, in the Canadian context, this push for, approvals of national interest projects that would not necessarily have to comply with standard environmental assessment processes and so on. And we're also seeing less embrace, I would say, of key principles of environmental democracy, which are very closely linked to the human rights and environment conversation. So I think the opportunity is, of course, with the UN General Assembly resolution recognizing the right to a clean, healthy, and sustainable environment as a right. the recent International Court of Justice climate advisory decision, again, clearly embracing and recognizing that right exists. The Inter-American Court of Human Rights advisory on climate change and human rights, which elaborates in greater detail about the procedural dimensions of those rights, about linking the right, describing the right as an autonomous right that also that in essence gives nature standing. All of that is happening at the same time that there is this pushback and rollback. And this is, I think, an interesting and troubling moment, I guess, in environmental circles, to try to figure out not just how can we ensure that, CSDDD type supply and value chain relationships are accounting for environmental impacts, but how can we make sure that basic environmental law and environmental democracy initiatives in developed countries, as much as anywhere else, are not rolled back. So for the Canadian context, I say this often in environmental circles, but not so much in the business and human rights one, is why are we not a party to the Aarhus Convention on Access to Information, Public Participation, and Access to Justice in Environmental Matters? And that matters, I think, for the trade conversation, because these EU member states are all parties to this treaty. And so there's certain basics when it comes to environmental democracy that are not embedded in all provincial or territorial laws in Canada, and in fact are sometimes being rolled back. And I think whatever shape the CSDDD or others will take, they will assume those principles, because in fact, this is part of a global movement that is linked to the right to a healthy environment. And Canada is not fully on board this yet and needs to be.
Thank you, Sarah. And this will be my last question to Penelope, Nadia, and Sarah. And please, the audience, if you can type in your questions in the Q&A section, that would be great, because I don't want to monopolize the conversation. So Sarah, Penelope, and Nadia are happy to answer your questions. So please, after this question, I'll throw it to the audience. All right, so this is the last question. Are there opportunities for collaborations? For example, I cited the Canada, UK, and Australia recently released a voluntary multi-jurisdictional reporting template and guidance for the forced labor legislation. Is this something that we can replicate in the HRDD regime, especially looking at the Canada-EU interface? Anyone can go first, either Nadia or Sarah.
My simple response is OECD multinational enterprises guidelines. Try to follow those as closely, or be part of the conversation with 50 plus other states about what this should look like, and then what this means on the ground in terms of implementation and reporting and other things. It's a real opportunity for multilateral engagement that we shouldn't miss.
Thanks, Sarah.
Yeah, I think that this is, it's a possibility, and I'd be interested to know politically what's happening in some of the discussions between our Prime Minister and the EU about, about human rights due diligence. Like, is there anything? I don't even know if there is anything that they're saying, but, it could be a pressure point, and it could lead to something like this, given that they've, created this template, which I was surprised to hear about. Because I suppose it's possible. But, Canada just has, at least the civil service has really pushed back against hard law, and really held the line on voluntary self-regulation. But you never know, if we're trying to encourage more trade with the EU, maybe this will be one of the pressure points.
Yeah, I wanted to say the same as Sara. Basically, I don't know if we need yet another process for discussions around those questions. I think certainly between the EU and Canada, the OECD is perfectly capable, I think, of handling those discussions, and they are happening there, you know, and this is always one of those mysteries of governments, you know, that they would be super engaged in one process and then on the exact same topic be completely unwilling to move. And often it's because it's different departments who deal with these issues, and or they just don't realize it's the same thing. It's one of those mysteries that I'm not really sure why it's going that way. But it seems to be that this due diligence process has really now crystallized a lot of complaints around how it's too complicated to put in place, etc., as if it was a novelty, you know, but it isn't. The companies have been supposed to do that for many years. So this idea that some are surprised around the fact that they're supposed to respect human rights and show that they do is is disappointing, frankly, even from companies and countries where you would think that progress has been made. This is really encouraging the wrong types of companies to have a moment, and I think that's regrettable. But yeah.
Thanks, Nadia. And I think I do not see a question yet. I probably will be wondering whether that's a technical issue or maybe I'm just missing something from the Q&A box. But let me give this a moment. Now, Nadia, concluding thoughts in 2 minutes or 3 minutes about the process, where we are now, and the future.
Yeah. So, like I said, we had a directive adopted, and now it's being renegotiated. Again, it's part of a bigger package. I think this is important to have this in mind. This is not an attack just on the CSDDD. It is also an attack on other pieces of legislation, and particularly the reporting directive, and now the deforestation regulation as well. All around corporate sustainability, human rights, environment. So it's all in the same area. And what we see now is, again, the EU Council and the EU Parliament are going to have to agree with each other on a text. And I insist on the history of this because we've come a very long way, and the original proposal of the Commission was very different from what was adopted in May 2024. And going back to, we talked about the mining sector, of course, very relevant for Canada. The original proposal of the directive had separate rules for sectors that were explicitly considered high risk for human rights and environmental issues. And the extractive sector was one of those sectors, together with the usual suspects, agriculture and textiles. And so already what we have, it's such a watered down version compared to what we could have had. So that's the context, which I think also goes on to explain, perhaps on a more personal level, how tired people are, and especially civil society organizations working in this space in Brussels, how much of a blow this has been after years of round-the-clock work. To see that put back on the table is really very complicated to deal with, I think. But anyway, we're back at it, and I don't have the exact date, but I think the final vote in the council is supposed to be a month from now, if I'm not mistaken, 24th of October. I would have to recheck that. I haven't rechecked before, but it's imminent, right? I mean, we should know very soon if this amendments, those amendments basically will be adopted. And then if they are, then starts again the 2 years for transposition, etc. So that's where we are. Yeah, it's also anyway, that's the process itself. I think more broadly, it's really problematic because this is a rule of law issue now, right? Things have been negotiated at great cost, at great length. You know, there's been a long process, and it was adopted, and now it's put back on the table. And why? You know, like this was adopted, so this was it. This is problematic because it sends a signal that nothing that the EU does is actually, you can't rely on it, right? So that yeah, there's a wider problem there with this whole process.
Can I pick up on something Nadia said there? I think I didn't realize that the proposal in the EU initially was sector specific. And I think that's very interesting when we look at the Canadian landscape, which initially started out very much with a focus on mining internationally, and then with the core moved to mining and textiles, and then with the most recent strategy is sort of taking a broader brush position. And I say that because, you know, initially I was very focused on mining. Now that I'm at Dalhousie, I'm looking at all kinds of other things, including ocean sector things. And I have to say, I was on a webinar yesterday listening to somebody talking about the conduct of a Canadian-based company engaged in novel marine carbon dioxide removal stuff in the UK. And it was just like listening to the story of an exploratory mining company that didn't know anything about human rights and environmental due diligence. It was astonishing, and I was almost laughing. But I think the point is that they, you know, eventually gave up and pulled out after everybody was absolutely furious with them, completely understandably so, because they did no environmental baseline studies. Does that sound familiar? They didn't talk to anybody. They just started dumping stuff. It's like, this is the point is that the lessons from the human rights and environmental due diligence work that has been going on for decades is absolutely applicable to so many different sectors, even though it might look different. And education on this is vital for all companies. It doesn't matter if you're, you know, if this new very, there's a lot of problems with the MCDR stuff. There's potential, I don't know, but how it's done, you know, it matters. And the lessons that come from this work is equally applicable to so many different areas. So it's such a shame that governments are not taking it really seriously when it comes to educating businesses, and that, you know, I don't know, business schools aren't doing more, et cetera, et cetera.
Good. Sarah, so we can do more on education. All right. And I think that's the point you're trying to make. But how does it translate into responsible business conduct? All right. But because that's
I think there are two dimensions to education, right? One is educating businesses so they understand what it is they're supposed to be doing. But the other is actually promoting the guidelines, for example, in the NCP process, so that when I'm talking to people in Nova Scotia who are concerned about the behavior of a particular company that's investing here and starting to do this and that, they know that there is this expectation, even if the Nova Scotia government has changed its laws or is trying to encourage certain development processes. They know that there still is this expectation, and that there is an actual, it would be nice, credible mechanism to go to complain to talk to the company about what the expectations are and should be. Yes, ideally, all our governments would be passing great laws and would not be repealing and rolling back protections. But that's not the world we're in, and at least we should have this, you know, so the education is both ways, right? Like if companies don't know about it, and if those who are impacted also don't know about the mechanisms that in theory do exist, then this is very problematic.
Mm-hmm.
Thanks, Sarah. Penelope.
Well, I'll say something about education because and then something else, but I think that we need to educate the government and the departments also about this. There are too many people who actually don't really understand the impacts of business activity, and what can be done, what ought to be done, what other states are doing. I think that needs to happen. You know, and people who are advising legislators as well, policymakers, need to understand this, and you know, and why it's absolutely crucial that we do something. I mean, we are facing an existential crisis with climate change, or the triple planetary crisis, as Sara has taught me. But I guess the other point I wanted to make was that in Canada, at least, like our government is distracted right now, and they seem to be operating from this idea that you know, we're going to take care of the economy first and then protect human rights and the environment afterwards. Well, we'll get to that part. We just need to act on the environment. And I think that is very dangerous. And it's an opportunity for corporate lobbies also to, you know, I don't know, stake a claim or roll back what's already done. So I think what we need to, you know, there are things that need to happen. And one of the things that was happening before the government was prorogued was that apparently there was they were developing you know, a human rights due diligence law in relation to forced and child labor, which, although not sufficient because it only covers, you know, 2 human rights, would have been a start. And then we also need to get this the ombudsperson back operating. We need to appoint somebody, and we need to give her the powers to compel witnesses and documents so that it can operate as a credible, effective remedy for people who are impacted by Canadian corporate activity.
Thanks, Penelope. Those are very concise and sharp concluding thoughts from the three of you. And I think I am not sure I see any question on the Q&A chat box, but I've opened the chat box for people to chime in. I think I am also nearing the end of this session, but let me go at another question. The directive, what impact does it have on the BHR treaty that is currently being negotiated? Are we going to be looking at a rollback, right? Is it going to have any effect on the negotiations going on?
Maybe I can have a go at this one. What can I say? I think the EU has been not very active in that negotiation, and there's been a lot of advocacy done in Brussels to change this, to get the EU to be more active in this negotiation, to show what it stands for, or what it claims to stand for, which is corporate accountability, or at least that was the message until not so long ago. And they haven't done that. So at first it was, we don't have a mandate. Then it was, we're negotiating our own thing. So let us do our thing. That's our way of dealing with this. We're doing it us, and then we'll see. And now that it's a mess, you know, that it's back to negotiating phase, I have very little hope that the EU will show up. And the next session is in a month, 20 to 25th of October in Geneva. So basically coinciding with the whole process that will have to happen for the adoption of apparently a revised form of the directive. So I don't think again, I don't know this intimately, but I think it's pretty safe to say that the EU is not going to be leading or playing any leading role in this negotiation, at least this year. And, you know, I think that's regrettable, because at the end of the day, the responsible business conduct agenda, the corporate responsibility to respect principle is much wider than due diligence. Due diligence is a way that companies can meet this responsibility, but other things also are important. And this responsibility is much broader than the due diligence process. And the treaty is an opportunity to go further with those principles rather than, always tie things back to what is essentially an instrument of corporate governance, the due diligence process. So I think that's regrettable, but I don't think the situation we have now is going to hugely impact this negotiation because they've already been absent. So it's, in that sense, it's not going to change much, I think.
Thanks, Nadia. Sarah or Penelope, you want to add to it, or that's fine?
I don't, Penelope, do you have something to add on
Not
this?
really, no.
So with that,
Going to make
Sarah.
just one other quick point, which is following on Penelope's point about the Canadian government being preoccupied, and perhaps linking back to the sort of questions you're asking about extraterritoriality. I think it's important to note that the key thing, there are many things coming out of the Trump administration, but one very firm thing is a pushback on responsibility across borders. It's very much an agenda of self-interest and bounded sovereignty. And so that is very much a force in the world, which I think is currently influencing how many governments are responding. And it's obviously an unfortunate and highly detrimental force.
Thank you so much, Sarah. I think with that answer, I am also looking at the chat box and the Q&A section. I do not see, and I'm not sure whether this is due to my own technical fault, but at this point, I would invite us to join me to thank our panelists. They've done an excellent job. They've given us insightful analysis about the CS triple D. Oh, and now I have a question. So let me take the question. I think we have roughly 7 minutes more, and then that's it. So the question is this: how will the EU ensure that the corporate due diligence translates into real, measurable improvements in human rights conditions on the ground, particularly in global South countries where Canadian companies operate? This question is to the three of you, so it wasn't specifically directed to any.
Yeah, I can try to answer this because this is a real question, right? This question of what companies should do, how do we check that they do what they should do? What are they saying they're doing? This whole reporting versus due diligence obligations. And it's particularly important for the companies that fall within the scope of the directive, but that are not EU companies. Because for EU companies, there is this mechanism of a national authority in each EU member state, which will monitor what companies are doing. What kind of powers will they have? How serious is these checks going to be? Those are open questions, but at least there is this process. For companies that have business in the EU and that fall within the scope of the directive, because of that, we don't really know who is supposed to check this. And that is the short answer. So that is definitely a gray area, within the directive. But even without going that far, I think even for EU companies, these questions of who is going to check and with what power is, of course, very, it's very important. It comes down to, I think, what this directive is trying to do is to profoundly change the way companies do their business and make their money. And that, for some companies, is a completely different way of thinking about how they operate. And it will take time, because some companies are coming from a long way on these questions. It will take time and education, and it's not because we have a few people checking that it will profoundly change things, right? So it's nice to have a monitoring system, but at the end of the day, we need change in behavior, and those changes cannot all be monitored through this institution. So how will the EU ensure? They won't ensure, or they won't be able to ensure, but this is part of a process. Yeah, that it will. The idea was that it would strengthen what we already have through other instruments. And civil society, of course, has a big role to play. Yeah, because that's the watchdog. These are the institutions that can bring to the fore issues that have come up and do their work, which is to bring those issues to the attention of the public. So that's a big part of this ecosystem.
May I ask a question about that? Because I've thought, was there not there under the original directive, was there not a private cause of action that is now no longer there under the omnibus directive? Because that would have also, the threat of liability might also have helped to ensure that.
Yeah, but that doesn't mean it's complete. Yeah, I was checking if I was muted. That doesn't mean it's completely out, because there's still domestic, sort of the possibility of cases at the domestic level, and there's huge differences between various EU countries. So it's not like it would be completely out, it's just that it's not harmonized.
Mm-hmm. Right.
Yeah.
Okay. Thanks.
Thanks, Nadia. It seems the questions are coming late, but let me take one more question and then we can wrap it up, because we have just 8 minutes more. This is from Ashno. It says they're saying thank you for the answer. Just a follow-up question: what mechanisms are in place to monitor whether companies are genuinely meeting their due diligence obligations under the EU directive, particularly in relation to child labor and other human rights abuses in lower income countries?
So for now, we have nothing, but like I said, because the directive is, there's a stop the clock, and there's, at this moment, nothing. But let me say, what is in the 2024 text and what is in the omnibus. The original directive, adopted in May 2024, says that each EU country will have a national authority tasked with monitoring the implementation of the directive with the companies that are in scope. And also, these national authorities would have the capacity to issue sanctions, and quite substantial sanctions in terms of fines, to companies that don't comply. So this was the mechanism. How it was going to be in practice, with what powers, etc., was one of those things that were left for the member states to decide in their transposition process. So civil society in EU member states were already preparing their advocacy efforts with their own governments to ensure that this national institution in each of those countries were going to be with sufficient power and funding and staff and education, etc., all the things we've talked about here. So that was already going to happen. Now the proposal is that these institutions would have less power, right? Because they would only be able to, Jen, I can't remember how it's phrased now because I don't have my slides up again, but they instead of a yearly check, they would do every 5 years, which of course is a lot less. A lot can happen in 5 years. and also that the minimum sanctions, the cap would be lifted, meaning that the sanctions wouldn't be that high in terms of money. So it's all going in the wrong direction, and already we had very little. And basically, to answer your question, what mechanisms are in place? Almost nothing is my short answer. Again, we rely in this area very much on civil society organizations' work, on investigative journalism, and on these people who actually bring these questions to the fore rather than official institutions, which, to be fair, cannot be behind every company. You know, so there's something there along the lines of, yeah, how do you monitor with limited resources is, I think, the key question.
Thanks, Nadia. I think we are out of time. Please join me in thanking our panelists. They've done a tremendous job trying to unpack this and provide insightful analysis. Please, if there is an emoji button, just put up a thank you button or a clap button, just to appreciate them for the time and for actually giving us this. Please, the recording will be uploaded on the forum's website. I would definitely be rewatching this because as I go through my own research, these are some of the questions that I would want to think about as I write my own research. So thank you so much, Nadia, Penelope, and Sarah. I don't see an emoji, but I think that's also a technical fault. But
And thank you to you for hosting.
Thank you for putting this together, Akin. Yeah, it's a great pleasure.
It's a pleasure.
Really great to hear everybody's perspectives too. So thank you.
Thank you. I think I okayed it. It's in the chat box. All right. Thank you. All right. So everyone have a good rest of your day. We look forward to hosting another webinar soon with another different set of panelists, who would also be engaging with timely and very informative discussion about business and human rights. So till then, enjoy the rest of your day. Thank you, everyone.
Bye.
Thank you. Bye.